Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employer locks out employees during a suspended strike. May replacement labor be used? Now, as we know, an employer who embarks on a lockout may not, as a general rule, use replacement labor to perform the work of the locked out employees. There is, however, one exception found in Section 76 of the Labour Relations Act, and that is that replacement labor may be used if the lockout is in response to a strike. Now, the matter I want to discuss is the Constitutional Court matter between NUMSA and Trendstar. Firstly, let's look at the facts. There was a wage dispute between Trendstar and NUMSA relating to NUMSA's demand for the payment of a once-off gratuity to employees. After conciliation failed, NUMSA gave Trendstar notice that its members would embark on a strike on 26 October 2020 and indicated that the strike would take the form of a total withdrawal of labor. The strike commenced on 26 October and continued for several weeks. On 20 November 2020, NUMSA notified Trendstar that it was suspending the strike at close of business of that day. However, NUMSA did not call off the strike and the dispute between the parties remained in place. On the same day, and shortly after receipt of this notification, Trendstar gave 48 hours notice to NUMSA of its intention to lock out its members with effect from 23 November 2020 with the view to bringing in replacement labor. Trendstar's view was that any lockout in response to the strike would entitle them to bring in replacement labor as per Section 76(1)(b) of the LRA. NUMSA approached the Labour Court on an urgent basis to interdict Trendstar from using replacement labor during the lockout. NUMSA did not challenge the lawfulness of the lockout, but alleged that it was not in response to a strike because by the time the lockout began, the strike action had ended. The lockout was therefore offensive and not in response to a strike. Now, the matter was heard by both the Labour Court and the Labour Appeal Court and eventually made its way to the Constitutional Court. And this is what the Constitutional Court decided. At the Constitutional Court, the judges had to consider two primary questions. The first question was, were the employees still on strike when the strike was suspended? And the second question was, what does in response to mean as set out in Section 76? Now, in terms of the question, were the employees still on strike when the strike was suspended, the court had the following to say. In order for there to be a strike, as defined in the Labour Relations Act, there must be a concerted withholding of labour, and this concerted withholding of labour must be for a specified purpose. If employees are not refusing to work, and are not retarding or obstructing work, they are not on strike and no strike exists. The court held that in the present case, the strike took the form of a complete withdrawal of labour. The suspension of the strike, coupled with the tender of service as from Monday the 23rd of November, meant that the strike came to an end at 5 o'clock on Friday 20 November. As from Monday morning, the employee's absence from work was due to a lockout, not a strike. Trendstar did not reject the tender of service as unacceptable or incomplete. Instead, it excluded the employees from the workplace in terms of a lockout despite their tender of services. So that dealt with the first question. And turning to the second question, what does in response to mean? The court differentiated between two possible interpretations of a lockout in response to a strike. The court said that the first interpretation characterizes lockout concerning what caused the lockout to be implemented. For instance, if the lockout was implemented because the employees went on strike, one could argue that the lockout was in response to a strike. This interpretation accounts for strikes that are currently occurring and strikes which have come to an end. Turning to the second interpretation, the court said that this interpretation involves a consideration of the word is in the phrase, the lockout is in response to a strike, and taking cognizance that this interpretation is in the present tense. This interpretation means that the right to use replacement labor would depend on whether, at the time this replacement labor is employed, the lockout is in response to a present strike. The judge or the judgment uses the wording, the strike must still be underway at the relevant time. And this interpretation would not account for past strikes. Now, colleagues, the Constitutional Court ultimately preferred the second interpretation. It found that even if notionally Trenstar's the decision to give notice of a lockout was in response to the strike, which had lasted several weeks and was not quite over when the lockout notice was given, the right to use replacement labor no longer existed when the lockout began on Monday morning. So just in terms of our comment, the court giving preference to the second interpretation, it means that employers must fully understand the definition of a strike to determine whether there is indeed a strike. The utilization of substitute or replacement labor or workers during a lockout is contingent on the occurrence of a strike, rendering it legal only when there is an active strike characterized by both labor withdrawal and a demand. However, this approach presents significant operational challenges for business. Under this judgment, the legality of replacement labor could change rapidly. It could be lawful one moment when labor is withdrawn and there's a demand, and in the next minute it can be unlawful when the labor withdrawal is temporarily halted. Now, in cases of intermittent strikes, where employees switch between striking and suspending strikes frequently, employers may find it challenging to maintain a consistent labor supply. This challenge is aggravated by the fact that replacement labor is often not readily available. So if you are dealing with a current matter similar to this, kindly make contact with us for advice and guidance. That then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. As I mentioned, if you have any questions or comments, please let us know. You can contact us at info@massconsulting.co.za. Also, if you're interested in staying up to date with the latest news and insights on employment law, be sure to visit our website and social media pages. I'll see you next time. Bye-bye.